Contract modifications are a critical aspect of business and legal relationships that often go overlooked until problems arise. Understanding how to properly modify contracts can save you from costly disputes and legal complications down the road. A contract modification is any change to an existing legally binding agreement between two or more parties. These changes can occur before or after signing the original agreement. But one crucial requirement remains constant. All parties must consent to the modifications for them to be valid and enforceable. Contracts appear throughout our daily lives, from employment agreements and home purchases to phone service plans and even credit card transactions. While some contracts are routine, business-related agreements typically involve significant negotiation and should be reviewed by legal professionals before signing. Contract modifications become necessary for various reasons. You might need to extend a contract's duration, alter the items or services covered, adjust quantities, change payment terms, or modify delivery schedules. Sometimes modifications are required due to statutory requirements or court orders, rather than the parties' preferences. There are two primary types of contract modifications. Bilateral modifications occur when all parties agree to changes, making this the most common form of modification. These typically involve negotiation and written amendments. Unilateral modifications, on the other hand, are changes made by a single party, usually only permissible under specific contractual clauses that grant one-party modification rights. Contract modifications can also be categorized as substitutions, where an entirely new agreement replaces the existing contract, or as additions and deletions that adjust scope, price, or terms without replacing the entire agreement. When considering legal requirements, several factors come into play. Contract modifications must comply with contract law principles such as mutual assent and consideration. Written modifications need to adhere to the statute of frauds, which requires certain agreements, like real estate transactions, to be in writing. You should also check whether the original contract contains a no oral modification clause, which would make verbal changes unenforceable. State laws regarding modifications vary significantly, with some jurisdictions imposing stricter requirements than others. Failing to follow these legal considerations can result in unenforceable modifications or costly legal disputes. You can modify a contract at any time as long as all parties consent to the changes. Minor modifications may be handwritten on the original document and signed by all parties, while major changes typically require renegotiation, reprinting, and resigning the entire contract. If the original contract contains specific instructions for making modifications, these procedures must be followed. Before modifying any contract, prepare thoroughly. Make a list of necessary changes, note any unfair provisions, document when you decided to make modifications, and consider how the changes might affect all parties' rights. It's generally easier to modify a contract before signing, so don't hesitate to negotiate original terms. If performance has already begun, be prepared to present compelling arguments for modification. Best practices for contract modifications include reviewing the original contract to identify any clauses that dictate the modification process. Always document everything in writing, even if verbal modifications are technically allowed. Negotiate terms clearly, ensuring all parties understand the scope, timing, and financial impact of the changes. Confirm that all involved parties provide their informed consent to the modification. Consider consulting legal counsel to ensure compliance with applicable laws and contractual provisions. Once modifications are finalized, update all copies of the contract to reflect the changes. Certain contract clauses directly impact how and when modifications can occur. Amendment clauses define the process for making changes, typically requiring written consent. Change order clauses, common in construction and service contracts, allow for modifications in project scope, cost, or timelines. Force majeure clauses permit adjustments due to unforeseen circumstances like natural disasters or pandemics. Termination clauses sometimes lead parties to modify rather than terminate a contract outright. Contract modifications can have significant business and accounting implications. Changes to pricing or deliverables may affect revenue recognition under generally accepted accounting principles. Modifications might require adjustments to expenses such as labor costs or material procurement, Tax liabilities and deductions could be impacted by changes to pricing or payment terms. Financial statements and disclosures may need updating if modifications significantly affect revenue or obligations. Disputes over contract modifications typically arise when one party disagrees with changes, when there's misunderstanding about the scope or impact of modifications, or when contract terms are ambiguous regarding the modification process. These disputes can be resolved through negotiation, mediation, arbitration, or litigation, if other methods fail. Proper documentation and clear contract language are your best defenses against modification disputes. Understanding contract modifications is essential for protecting your business interests and maintaining productive relationships with partners, vendors, and clients. By following proper procedures and best practices, you can ensure that your contract modifications are legally sound, mutually beneficial, and less likely to result in costly disputes.